All right, I have 7 o'clock. I will call the town board meeting for February 22nd, 2023 to order. First item is the agenda. Patrick, any changes?
Yes, Mr. Chair, if it pleases the board, please add to your public hearing business supplemental information 7A for 2659 Richard Drive, town attorney findings and decisions for three variations on whatever your determination may be. And 7B, additional information as well for public hearing for the Universal Forest Products at 4141 Hoffman Road. It is the Marcus Construction correspondence. With that, I would submit to you this evening's agenda.
Board have any?
Mr. Chair, I spoke to Pat about that maybe we should have a special meeting called for the legislative gathering.
Oh, yes.
And could you read the date? And I'll add that. I'd like to add that to the agenda.
Tuesday, March 7th, 4:30 to 7 p.m.
Does that have to be in the open part, or can that just be, can't put it through as consent, could we?
Isn't that the day of your town board?
We're on the second Tuesday.
Yeah.
Yeah, so that'd be this.
And so the annual meeting is the Tuesday following.
Okay, I was thinking.
Yeah.
All right, so you just want to add agenda
Couldn't count right.
9A to call for a special board meeting?
Sure.
Yeah.
All right,
I'll add that motion.
all right. All right, any motion to approve the agenda as amended?
So moved.
Second.
All in favor, say aye.
Aye.
All opposed? All right, item 3 is approval payment of bills. Steve, you sign off?
I signed off on the bills. Move to approve.
Second.
Motion's made and second. All in favor, say aye.
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 All opposed? All right, item 4 is approval of the minutes, February 6th. Any changes?
I saw none, but so I move to approve.
Second.
Motion's made and second. All in favor, say aye.
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 For the record, I'll abstain. I wasn't here. All right, item 5 is consent agenda items. We got 5. The board pleases, or you wish to pull any of these?
I will move to approve the consent agenda as submitted.
I'll second that.
Motion's made and second. All in favor, say aye.
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 All opposed? That motion carries. Item 6, we have old business, which is none. 7 is the public hearing. First one is this Richard Drive. I'm going to need a motion to waive the reading.
I'll move to waive the readings that it was properly published.
Second.
All in favor, say aye.
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 All opposed? That motion carries. Then I need a motion to open up the public hearing.
Move to open up the public hearing.
Second.
All in favor, say aye.
Aye.
Who's going to take this one?
I can.
Mike?
Yeah. As the town board is aware, town staff has taken significant steps to educate town residents on proper storage of RV, boats, camping trailers, items of that nature. The homeowner at 2659 Richard Drive has requested or has appealed an order from the town to comply with the RV storage. A hearing was held with the hearing officer, and this is the public hearing for the town board determine appropriate action. Chad has prepared some resolutions. It could go into more depth on those.
Chad, you want to go over those for us?
Sure. Now, again, the facts are, we already know what the facts are, and the hearing has been held. And I've created 3 alternatives for you. Alternative number 1 is that Lisa Love simply be given 15 days to remove both motorhomes, and if she doesn't, the town will order them to be removed themselves. Number 2 is she is allowed to park one motorhome at the property, and the other has to be moved to moved in compliance, or moved to a spot that complies with the ordinance. The third is the town simply allows her to maintain both units, both motorhomes at the property, and until November 1st of 2023, at which time she has to properly park both units. So she has to comply with the ordinance. And again, the reason basically for the three alternatives is a question of practicality. Within basically a month, she'll be allowed to keep both of them in the driveway anyway. So it's a question of which one do you want to go with. And the fact is, the reason why I prepared one to allow her to keep only one and comply with the other. She does have a property in White Bear Lake, which she represented she could park one there. And given the fact that she uses them for daily transportation, she doesn't need two of them, she only needs one of them. So if you have any questions about my reasoning, go right ahead.
Not necessarily about your reasoning, but that we also have a total square footage
That's correct.
part of the ordinance, and by removing one, that puts her at least under the 300 square foot. Is that correct or not correct?
Well, that's right, but Mike, go ahead, but I mean, she's pretty close to being 300, even at 300 square feet, she's gonna have a hard time parking one.
Yeah, the two together exceed the 300 significantly. I don't have the numbers right in front.
But one would get it close to the 300? So
Correct.
we don't have two parts to this to have to deal with?
Correct, one would meet the 300 square feet requirement.
Barely.
Just barely. Okay. Yeah.
Scott?
I don't have any questions. No.
All right, hearing none from the board, I would ask for a motion to open up for public comment.
I'll move to open it for the hearing for a public comment.
Second.
All in favor, say aye.
Aye.
All opposed? Is there anybody here who wishes to speak to this issue? Once, twice, three times. All right, motion to close.
Move to close.
Second.
All in favor, say aye.
Aye.
All opposed? All right. I personally, I think because Mike's done a terrific job of, I think, 120 some residents are affected by what we do here. I don't see how we can specifically show priority to one individual, especially when this is quite over the top with two motorhomes, much less just one. And I know she has, whether she likes to or not, she could, I believe, take a tree down and park this next to her garage and be in compliance, correct, Mike?
Yeah, there would be some, I don't know, wouldn't want to use significant landscaping, but some work would need to be done to prepare a proper legal parking site on her
I
lot.
mean, when you look at what it costs you to store a motorhome compared to what it would cost her to just get her property set up so it could stay there, it might be a wash. But I'm in a kind of I think we should not make exception for this case. Scott?
I totally agree, especially, I know there was a hearing held and there was a recommendation, but I wasn't in favor of what was being recommended, to carve it out special.
Steve?
No, it's a slippery slope when you start granting things, and it was a well-published ordinance that we do it every year, pointing out what the requirements are, and it takes our officer here to spend tons of time getting to this point where we are today. I don't see any reason, and granted that in a month it becomes a little over a month, it becomes a non-issue. Mm-hmm. But no, I think she needs to move it. She has other options that are within her control.
So which means, are we just going to let her continue the end of this year and then make her comply next year? How does that work, Chad?
Well, I mean, that's no
option
matter what.
three.
She has to comply by November 1 of 2023.
Okay.
Yes. That the options, as Chad pointed out, that's not really one of those options, though.
Which,
To let them stay there for 2 months.
Which I
Well,
thought
that
she
is
might
option
be
number 3.
that's option three.
You're in favor of letting her keep both of them out of height?
No, I was just, I thought she was going to be gone by now with one of them to start with. I thought,
I think they're both gone right now, right, Mike?
Yeah, they are both currently
Not present.
stored on
well, they're not coming back for the winter?
I haven't spoken to the homeowner. The way I understood it, she was leaving south for the remainder of the winters.
Well, both of them went south?
Don't know. One of them at least.
Well, so part of our motion would be that neither of them can come back for the remainder of this year, and she has to comply for next year, correct?
Well, neither of them can come back before March 31st of this year. After that point, they can both come back
For ordinance.
for ordinance, yeah. Oh, Mike, I think about it, there's a problem with the storage area, isn't there?
Yeah, so they would not both be able to come back because they'll be over the 300 square foot.
I forget that 300 square feet applies year-round.
Correct.
All right, so does that still fall under one of these three, or do we have to modify one? Got a
Well,
little
it'd have-
confusing here.
Well, actually, whichever one you pick, you'd have to modify it that
With the 300 square feet.
feet, yes.
The number one, that she's in violation, that's, I think we're in agreement in all three of these options that she's in violation of the ordinance.
Yep.
On number two, that she has 15 days for the date of this decision to park or store both in compliance, and failure to comply, we can do what we said we're going to do. And then we have to also add about the square footage, and that next year, we're not going down this road again, that she has to completely comply, as you noted in item number 3, or 2 and 3, that commencing on or after November 1st, 2023, she shall park or store whatever in a manner that conforms with that ordinance. I think that's kind of what you were just
Right.
saying. So,
Option one works as long as we have the
Yes.
300 square feet? Is that what you're saying?
we need to add that, but then we need to add this language under the second option.
Actually, under any of the three, she has to comply with the ordinance.
Yes, and I think we should just put it in there so it's very clear that we don't want to deal with this again next year. No misunderstanding then.
No.
So we can do that, I think.
All right, so we're saying option one, adding the max 300 square feet, which is still part of the ordinance.
Yes,
And then this number 4 of option 2.
yes. I'd move to do that.
All right,
You don't really need to add the 300 feet because it already says
ordinance.
you have to store them in compliance with the ordinance, and the ordinance says 300 square feet.
Okay.
So you're all set.
All right.
If you want to emphasize that, you could, but you don't need to.
Might want to.
all right. Are you comfortable with that?
Sure.
You look a little.
I'm a little confused, but sure.
So, members
Should I
of the
repeat?
board,
No, let Mike speak.
Go ahead, Mike.
so I believe the first option is what the board is looking for, 15 days of compliance. If I heard you right, you didn't want, you wanted the property in compliance this year.
Correct.
Actually, you were really saying you want the property in compliance now.
Yes.
And she's got 15 days to do so.
Yeah.
Which it sounds like she already is.
Yes.
Yeah.
And then, just for clarification, add that item that says number 4, so she's clear that we're not doing this again next year. You got to till November 23 to make sure you have other places to store your vehicles.
As long as the ordinance is referenced in your resolution, she has
should be
to
fine.
anyway.
Yeah.
Yep.
All right, that cleared up?
Sure. I'll second.
Just so we're clear, if the intent of the board is to require she remove both of them now, then number one is
Yes.
what you want. And I think number one's clear that she has to comply with the ordinance now. And that means for the rest of the, not just now, but for the rest of the year and in the future as well,
Subsequent years.
subsequent
All right.
years.
So
yeah.
to make it clearer for Scott, I'll based on town review and recommendation, approve number 1. I recommend board decision number 1 that says Lisa Love is in violation of the town ordinance number 35, section 7-6.2B, and that she has 15 days from the date of this decision to park and/or store both motor homes at 2649 Richard Drive in compliance with ordinance number 35, section 7-6.2B, Failure to comply with the decision will result in the town ordering both motorhomes to be removed from the property.
There you go.
I will second that.
All right, motion's made and seconded. All in favor, say aye.
Aye.
All opposed?
You understand, Scott?
I got it. Thank you for doing that for me.
No problem, partner.
All right. All right, the second public hearing is Universal Forest Products. This is item 7B. Again, I need a motion to waive the reading.
So moved?
Second.
All in favor, say aye.
Aye.
All opposed? Then I need a motion to open up the public hearing.
I'll move to open up the public hearing.
Second.
All in favor, say aye.
Aye.
All opposed? Mike, you taking this one too?
Yes. So before you this evening, UFP 4141 Hoffman Road, a continuation of a public hearing. Approximately 90 days ago, the town board approved amendments to the conditional use permit, allowing the construction of some steel frame structures on the property. At the public hearing, and I don't have the date right on top of my head here,
November 21st, town board meeting.
November 21st town board meeting. There was some conditions put on the conditional use to require some of the work to be completed, gain code compliance on the structure. And that is the purpose of tonight's public hearing. In your packet, there are some statements from contractors, basically requesting additional time to comply with the building code requirements. There's a lot of information in the packet there. If you have any questions, I'll be happy to try and answer them.
Scott?
Side question, but it had been brought up previously. I think there had been a concern or discussion about some cars that were parking and people staying at a parking lot on the property. Have you heard at all whether that's still the case, or has that?
Town staff has been working with UFP on a resolution on the abandoned vehicles on the property.
So they're still there.
They are, as far as I know, as of yesterday.
All right. Have you been out to see anything or received any subsequent plans since we last met at the end of January?
Yes, the town did issue a building permit for the construction of the steel structures and the repairs ordered by the engineer's report. The permit has been issued for that work.
But you've not been out to view any work that's been done so far?
I don't believe any of that work has begun.
Okay, and the second part of that from November, if I'm remembering right, was talking about a fire suppression project which was acknowledged to be extensive. And I believe that there had been some additional timing allowed for that to come up with a plan. Has there been any discussion whatsoever that you've been involved with on that?
The town has not received a plan for the fire suppression system. I did have a conversation with a potential contractor working with UFP on developing a plan.
But you've not seen anything since?
I have not.
Okay. All right. I'll think of others, but that's it. Thank you.
Steve?
The question, Mike, I see there was a letter included on February 20th of 2023 from Marcus Construction saying that they need more time, but you've issued a building permit. Is that for this anchoring portion anyway? Which
Yeah, the document in the supplemental package from Marcus Construction, I believe they were contracted to make the repairs by the engineer that had been documented by the engineer.
and the 120 days, as mentioned in the November meeting, was to have a kind of a finite plan. And this letter of February 20th that I'm referencing says that they want to extend this to complete that portion anyway for another till May 20th. But with a permit issued, doesn't that give them that latitude without, or is it the 120 days that we put upon them is the issue for that portion?
So that permit issued to make those repairs is valid for 180 days. And the town can extend that for an additional 180 days.
And when was
if
that
they
issued?
choose. I don't have the date right here.
But it was recently?
Yes, in January, I
So
believe.
they get a half a year.
Well, but this is a game too. I mean,
I-
they've had a year, and now when they're at the deadline, then they come in and get the permit thinking that now they're automatically going to get another 180. Chad, what's the legal ramification of that? Their CUP is technically, well, as of tonight, susceptible to being revoked.
Well, it is. I mean, that's exactly right. The fact is you could revoke it right now if you wanted to.
So, but now that Mike's basically issued a building permit, does that compromise that?
To an extent, it does. I mean, but Mike, does that building permit have any time limit to complete the repairs by? 180 days, isn't it?
The building permit is good for 180 days.
So theoretically, they would have now we've now given them permission to complete the work with 180 days. Though keep in mind, a building permit, we're not talking, really what we're talking about here is a violation of the zoning code to an extent as well, because the buildings aren't up to code.
Chad, part of it is the code issue is the non-sprinkler building, right?
Which
I mean,
is the
that
building code, yes.
Yes. But the non-anchored, I'm trying to get my hands around it. The non-anchored buildings, which is what the Marcus Construction said they can do, they can accomplish that within the 180 days based
Right.
on this letter. They get that. Anyway, it's the other part that's the real rub for me.
Oh, yeah, it's the fire suppression. That's the real problem. Because there's clearly no definite time that's going to be completed by.
Okay, so I guess that's my questions, and I'll wait and hear what they have to say. I'm sure there's someone here to.
All right, Mike, so the buildings in question, how many are there that have to be repaired?
There were 7 steel structures that the town issued a permit.
Okay, so you got 7 buildings that need repair. How many need the fire suppression?
1 that the
And
town is
They're,
requiring.
they're operating right now in those buildings.
Correct, as far as I know.
And is that violating health, safety, and welfare of the building codes to have somebody operating in these buildings?
The structure is in violation of the building code, that's.
Well, Chad, aren't we bound to at least red tag those buildings and stop them from working in it? Obviously, the company doesn't seem to care about their employees, but the board should.
For safety reasons only, I have a bit of a problem with that because really OSHA, both on the state and federal level, are designed to deal with those issues. And so to an extent, they've co-opted the field.
But Mike OSHA's not even been out there, have they?
I'm not aware of that.
I understand OSHA may be falling down on the job, but the point I'm making, or the point I'm trying to make is that OSHA, both at the state and federal level, have decided they're the ones that'll make the decisions as to what's a safe workplace or not.
All right, so also should the board make their decision on having OSHA go out there and inspect the buildings. If they have the final say if they're safe or not to work under.
You could. Though, keep in mind, though, it's not just, it's also the point that the building code says they have to have sprinkler. The one building has to be sprinklered. So they're really operating outside the building, they're in violation of building code.
That's only
Which
one.
is one, well, and what I was going to say is that because, yeah, it's only one building, but the point being is that building code, it's up to us to enforce that, not OSHA. So from that standpoint, there's no co-option. That field it belongs to us.
So rather than going down the path of safety, we should focus on codes.
Well, yes. I mean, granted, the code is adopted for safety purposes, but the point is we enforce the building code. And that's where our power lies.
So then, other than the fact that the one building is not sprinklered, the other 6 buildings are in violation of one of our codes?
So the other structures were, it all started out as one big building, and to avoid some of these fire suppression requirements, basically cut it into smaller buildings to avoid the fire suppression requirements. The smaller buildings do have structural requirements that they have to meet the state building code. And that's what the town's asking them to do, is meet the structural requirements
Mike, is this
for
similar
the
to
state building code.
Is this similar to a certificate of occupancy before you allow somebody to move into a house?
Yeah, the town has authority to issue a certificate of occupancy to any portion of a building, expansion, new building.
So in this case, the occupants moved into the house before a certificate was issued.
Correct.
All right, Steve, you have any more questions of Mike or the?
Well, I'd like to hear what they have to say first before I say anything further, so, on the questions.
All right, I need a motion to open up the public portion.
I'll move to open the public portion of the hearing.
Second.
All in favor, say aye.
Aye.
Aye. I gather there's a representative here. You have to come up, state your name and address for the record.
Good evening. My name is Brian Golanowski. My address is 4677 Province Way, Hugo. I'm the Regional Director of Operations for UFP White Bear Lake LLC. Thank you for hearing us today. To quickly address a couple of things, we've partially, the delay has been due to some administrative functions. We applied for the modified conditional use permit back on May 3rd, 2021. We were granted that. During that hearing, and if you look back at the recording at 23 minutes and 30 seconds, I noted that the wording on the conditional use permit didn't reflect all 7 buildings as approved by the Planning Commission. I asked that that be reworded to be consistent with the site plan as submitted, which had all 7 buildings on it. The conditional use permit was issued without that wording changed. We applied for a permit back in November of 2021. We were denied that permit because it was not consistent with the conditional use permit, a building permit. We had to start that conditional use permit process all over again and hire an architect and engineers to do the building evaluation. And that's what's taken so much time. We had an architect hired the day after we were told we needed to start the process. We tried 4 structural engineers before we found one that would do the survey on this building and come up with his structural recommendations. The day after he submitted his structural recommendations, we had the conditional use permit application refiled, and then it's gone through this process to get us to this point. So it has not been us trying to kick the can down the road. In fact, we want this to be done more than anything. The building in question that needs sprinkling has been there for 40 years. It had never been flagged for sprinkling before. In fact, on the initial walk that identified these 7 buildings that were at the time just 2 buildings as being deficient. The fire marshal and Mr. Johnson did not flag this building as requiring fire suppression at that time. They flagged other areas of our property that required updates in fire suppression. We completed those updates within 30 days of that walk. That was February of 2021. And then on a subsequent visit to inspect those, it was brought up that these other structures needed fire suppression. We had a contractor signed up to do the work back in April of this year. We were told to wait until we went through the conditional use permit process and the building permit process to do that. As soon as we had the hearing last November, we had a contractors under contract again. They lost 3 of their lead people and a bunch of their employees. They've been non-responsive. We've gone to other contractors. We have entered into a contract with a utilities contractor that is scheduled to start work on April 10th. And we found 2 other sprinkler contracts now that have given us quotes, and one of them is fairly certain he can have all the piping and sprinkler work done before April 10th, so that all he has to do is hook up when that underground utility is ready. So we are more than prepared. We have funds available. We're trying to push this through. There's been a lot of red tape to get through to get there. And I just would ask for your continued patience and understanding that OSHA was out last year. They did a full day inspection with 2 inspectors and gave us glowing reviews. We were cited with 3 minor violations that were resolved before they got there. None of them had to do anything with these buildings. It had to do with an air one that didn't have a pressure relief valve on it, a guard missing on a angle grinder in our maintenance shop that was on the shelf. So, I mean, we do care about the health and safety of our employees. If you come out and look at these buildings, they're full of doors. The operators that are in there are surrounded literally. There's a door directly behind them, and then there's 190 degrees to them that they can exit. They're small buildings. They're barely over the threshold requiring fire suppression. In fact, if the outdoor added structure wasn't as close as it is to the building, it wouldn't be over the threshold to require fire suppression. So I think when you hear about it without context, it sounds worse than it is. And if you were to see the property and see the progress that we've been making and the effort we've been putting into it, I would hope that it would satisfy that we're trying to do the right thing and trying to get it done and be a good partner. As for the abandoned vehicles, the Ramsey County Sheriff has been out 4 times. We had a tow truck out twice. Tow trucks can't tow it if somebody's in the vehicle, and they can't force somebody to get out of the vehicle. And these people know the rules and they know how to play the game, and they're playing the game. Our hands are tied. I don't know what more we can do with the vehicles. I don't want them there. They're not our employees. They're not anyone we know. We've tried leaving letters. We've tried providing resources for homeless assistance. We've tried being very polite and nice, and we've tried a stronger hand with the Ramsey County Sheriff. I can't violate the law and get them off the property that way, or I open ourselves up to more liability too, right? So I'm all open for suggestions on how to fix that one. There was an issue with on-street parking, I think, Mike, that you wanted to talk about. We would love for nothing more than the township to put up no parking signs on that street and not allow our employees to park there. We can't control what they do off our property. We lease the lot to the north so that we have employee off-street parking accessible for them. They choose to park on the street against our advice.
Mike, is Hoffman Road a county road?
That's a city street, I believe.
So half of it's ours, half it's the city?
Yeah, I believe so.
All right, Scott, you questions, comments?
No.
I have a question. Frank, you haven't been before us before, have you?
I was with you on a Zoom meeting that May 3rd.
You threw a lot of dates out of
Yes.
things that, that took place without us having any opportunity to really see that. And you mentioned the Planning Commission of May of 2021 and things. Just if there's any of these things in the future, it's best that we have this stuff up ahead of time so that we have some opportunity to put it in our data banks as to does it make logical sense. From my perspective, it's that I didn't know they were there 40 years and non-sprinkler personally, but that if if it's not legal, it's still not legal. Item 40 years ago, they may not need it to. I can't answer that,
Sure.
but we're dealing in the today. So I appreciate you telling us what you told us. So I don't have any other questions about that. So the 7 buildings, 6 of the 7 do not have to have sprinklers? I thought I heard him say they did.
That's correct.
You're only going to put sprinklers in one?
So we're sprinkling so the way the building that requires sprinkling is an old building that's been there, and we added this steel structure off the end of one of the garage doors to give us some covered storage so that when we have forklifts approaching that entry, that it doesn't have snow and ice on it and the forklift doesn't slide into our employees and operators. It's actually a safety thing, ironically enough. That attachment puts it over the square footage requirement to require sprinkling. So we're going to sprinkle that building, and we have one other building that we're going to add fire suppression to at the same time that's not over the threshold to require it, but we're just going to do it while we have the utilities out. The other 6 are very small. They're not, they're open-ended carports. They're 30 feet wide by 30 feet long, and there's no occupancy in them. That's just used for covered storage of wood, stacks of lumber, just to keep rain and snow off of them.
Have you shared with Mike documentation that your contractor's got this lined up to be done in April?
Yes, I've tried to keep Mike as in the loop as I can as we've gone. We've had some phone conversations.
Might have been part of the
I have some emails that I sent. There was a letter that the contractor sent that I did forward to Mike.
Is that Mike Lair you're talking about?
What's that?
The Marcus Construction one?
There's Marcus Construction for the structural repairs to the 7 buildings, and then there was a letter sent by Industrial Utilities, Inc. They've also applied for a permit to do the underground utility work to get water supply into the 2 buildings that we're putting fire suppression in.
We're missing that piece tonight. I am.
Okay. I sent that to Mr. Johnson last week on 2/13.
It was part of an email, wasn't it?
It's on page 59.
It was in a reply email to his email to us requesting updates.
It's part of the original packet.
Hang on. I guess maybe we did have it. Just didn't make sense.
Page 59.
All right. I take it back.
And they did apply for a permit this week. The permit's on hold. I believe they wanted verification that the 4-inch supply line proposed we put in was adequate to support the fire suppression system, which we should have an answer on very shortly.
All right, I guess, Brian, I want to set the record straight here. Those buildings were done without any permits, without permission. So when you talk about red tape and the process and the delays, that's not on us. That's on you.
Agreed. And
This was all caused by basically not following our ordinances. So now you're putting us in a position again where we've given you over a year, and now I hear that, well, we can't go in because of frost. I've been in construction my whole life. You can thaw frost. So that's not an excuse for me anyway, for you guys not to continue getting this done. So I just keep hearing excuses, not how you can't get it done. And the board is just about, we're losing our patience on this whole thing. And to start with, too, we've been asking for an actual owner, somebody with skin in the game of this thing. Now, obviously, you're just the regional director. It seems like the owners don't really care if we shut them down or not.
Well, we're publicly held, so I am an owner, as you may be too, in your pension or 401k. I'm not sure, but
Yeah, but there's got to be a board of directors. There's got to be.
if you would like me to see if the board of directors would come before you, I would gladly ask them. But I think I know what the answer is.
I'm really confused that no one seems to take us seriously, and that's why we're here tonight.
It's not that we don't take you seriously. We take it very seriously, and we've been trying to do the right thing. We really have. We've been told to wait. We've been told to go through the process. We've gone through the process. It's been incredibly difficult to get people to do anything. I mean, we've hired an architect. It took the architect 8 months to get through the process.
But you found somebody put up the buildings without, and I can't believe a legit contractor would do these buildings without a permit.
So
that to me alone boggles my mind.
So we were told by the manufacturer, these are pre-engineered manufactured buildings, that they were temporary movable structures and not subject to building code because they're carports. And you can literally pick them up. And in fact, when we cut them up from being the size they are and moved them, we literally picked them up with a forklift and moved the sections to another part of the yard and anchored them down per the plans provided by the manufacturer.
Yeah, I'm still not buying it. Me personally, I would like to see every building that's under Mike's jurisdiction for code compliance be tagged. You can't use them, period. I don't, whether you feel it's safe for your employees or not, we respect our building officials. And if he says those buildings are out of compliance and he wouldn't even issue a certificate of occupancy for you to even go in them until they're fixed, I can't believe you guys are still using them. I just don't understand why you're doing that. And like I said, you can thaw out the ground. You can get rid of the frost and get whatever you need for the pylons or the stabilizers, whatever you're putting in there for anchors. That can be done. Again, you guys are just finding a reason to push this out and out and out. And me personally, that's where I stand with this. I would not let you guys work in those buildings. I only speak for one of us, but that's where I stand. Scott?
Well,
I vented.
I am not nearly as versed as you are in construction. I come from a different background, so I rely heavily on what the code enforcement officer updates us on. And there's a lot going on, even in the township, and I learn every single day that I listen to him. But I have to respect his opinion and his thought process along with the attorney, because again, they're much more skilled in this area. It does seem like it's been a very long process. And is that normal? I've gathered that it's not, and that this is something that could have been avoided, but I can't speak as firmly as what you just heard because I don't have that experience. So I am relying on what I am hearing from others, that this is kind of like what we don't want to see normally. And we don't like to, I know personally, now I can say, we don't want to pull businesses that are in the township that are a benefit to the township. I don't like having it in here saying, what's going on? Why isn't this working? Get it fixed. Because then it becomes what, we're trying, and this is what we tried. Well, no, you didn't really try because this happened, and it goes down a bad path. So while I'm not going to speak as strongly as what you just heard, I am going to say it seems to me a little disappointing. But again, I'm rather new in understanding how construction works.
I think it's important to note that we had an 8-month delay because of a typo. I mean, we had a typo on the conditional use permit, and that prevented us from moving forward at Mr. Johnson's direction. To start that process over again with the conditional use permit application, hire an architect, submit a new site plan. The site plan that we submitted from a licensed surveyor was not deemed adequate, so we had to hire another architect to do it, even though it's the same surveyor that supplied the site plan the last time we got a building permit with all the same information on it. But it wasn't deemed adequate this time because it didn't have fire aisles drawn in. So we had to hire an architect to do that. That all took time to go back through the process when we had already gotten essentially substantive approval on what we were talking about. But we couldn't pull the permits because of a typo that said 4 buildings instead of 7. And Mike, you admitted that in our conference room that was a typo and
I'd have a different view on how that was stated.
I would encourage you to watch the video of the May 3rd town board meeting that we held via Zoom and go to 23 minutes and 30 seconds when, before it was voted on, I raised my hand and said, please note that the way it's worded in this is incorrect. It's not consistent with the site plan as submitted. I'd propose that we change the wording to the conditional use permit to match the site plan as submitted.
Mr. Chair, I don't believe that that's the issue at hand here. It's more of an issue, no building permits. You got to get building permits when...
I filed a building permit application November of 21, and you denied it because the conditional use permit had a typo. You said you couldn't issue a permit for all 7 structures because they weren't covered under the conditional use permit, and then you met in our office with our architect and said you'd realized that was a typo and it was on the site plan as submitted.
Chad, would that have been a reason to stop the process?
I don't want to contradict Mike, so I'm not going to really make a comment till I know more about this, other than to say that building permits and conditional use permits are two separate items. We're talking about two different animals here.
But you can't get a building permit for a building that's not approved under a conditional use permit. And that was the crux of the issue. Mike would not issue a building permit for 3 of the buildings because they weren't on the conditional use permit, because it worded it as 4 buildings, even though there were 7 on the site plan as submitted. And I pointed it out in the town board meeting where you
That
approved.
before
I
they
would
were,
push this point much harder if I were you.
is that before the one building was broken up into 7?
It was after, but as part of that May 3rd, it was before that. Part of the resolution in that was to break the buildings up. So that's what we were seeking approval for in that conditional use permit application, was to have the new buildings that were put on the property before my tenure, that not an excuse. I think we kind of had Scott Weir, who was our real estate professional at the time. He no longer works for us. And we apologized and said it wouldn't happen again. And I believe Mr. McKean, you said, please let this be the last time we do an after the fact conditional use permit application, which I fully intended on it being the last time until we had to come back and ask for it again because the wording was off. And respectfully, I don't want to, you're asking me not to push any harder, but you're talking about the livelihood of our employees and shutting our business down by not letting us operate. So I'm going to be passionate. I'm going to push back on what I feel is right.
Was there a site plan submitted when you were taking the one building into 7?
Yes, sir.
And that was under the conditional use permit you're talking about?
Correct. And that was what, yes.
So if the site plan said 7, but a typo said 4, I don't believe that would have been enough to constitute the conditional use permit being stopped.
Well, we filed the
If I
building
may,
permit.
I think what
application.
I'm hearing here is that what I'm hearing is that because the building permit was for 7 buildings and the CUP was only for 4, that Mike couldn't issue the building permit because it wasn't conforming with the CUP, which would require that the CUP be amended to require 7 buildings before Mike could issue the building permit. Mike, does that make sense to you?
Correct.
Correct.
So that's my understanding what we're talking about here.
And the reason the CUP said 4 instead of 7 was everyone in this room agreed on the phone, on that Zoom call, that it was just essentially a clerical error, a typo in how it got written, because the site plan was submitted with all 7 and reviewed by the planning council with all 7.
All right, if we get back to square one, this is just more confusing than what it's worth.
Yes.
A couple things. Chad, is the township anyway liable because of the people parking on that property because we lease that property to UFP?
No, we don't control it anymore.
All right.
And I think actually what could happen is I sympathize with you, but why don't you simply start a civil action of trespass and get a court order ordering the sheriff to remove them?
We started that. We had to post no trespassing signs, which technically is a violation of our lease with the township, but hopefully you'll overlook that. We posted those.
You could have simply called my office. We would have amended that for you. That's not a huge problem. Just give us a call and tell us what the problem is. Talk to us.
We were working with the sheriff to do that. So we posted the signs.
Okay.
And they have to be posted for so long. And then, yes, we're pursuing that avenue at this point.
Well, fine. If you're doing that, then that's, if you've started a civil action for trespass?
We haven't started civil action for trespass because I believe that no trespassing signs have to be up for a certain period of time. If that's not accurate, I will call our attorneys tomorrow and start a civil action on it. I want them gone as much as anyone, trust me.
Well, I believe you.
Yeah.
I believe you at that point. But no, you don't need to put trespass signs up. It's your property. You're leasing the property from us. You have control over it. You have the right to bring a trespass action anytime you want,
Okay, I will.
whether or not the sign's posted.
Okay.
Is that not what you heard from Ramsey County Sheriff?
Yes. Well, so Deputy Taylor Holm told us that we needed to post a no trespassing
I
sign.
think we're talking about two different things. I'm sorry to interrupt, but the sheriff's probably looking at it from a criminal standpoint.
Could be.
I'm talking about a civil standpoint. Yeah, I would see. Okay, that I understand.
That makes sense.
From a criminal standpoint, yes, you can't, they're not going to enforce a law unless people know that they're breaking a law.
Sure.
Okay, that makes sense. But there's nothing to stop you from bringing a civil action, writ of ejectment is what it's actually called, trespass, to get them off, get in a court order removing them anyway.
Okay.
I do it myself. I've done it myself.
So if they file a civil action and get a court order, Ramsey County Sheriff would still have to go out and enforce it, wouldn't they?
That's what you do. In fact, I've done it.
Would they then require a no trespass sign to be in place
No.
before they will do that?
No, because what you're doing is this. Now, I'll grant you, civil actions take some time, but the court order, if it's properly drafted, the judge will be directing the Ramsey County Sheriff to enforce it by removing these people. The same way you do an eviction.
Just to play devil's advocate. Sure. Would the judge then, before he makes that decision, say, what have you done to help get these people out? I mean, have you put them in contact with certain offices or had other organizations reach out to them? Would the judge try and get this to be worked out without issuing that?
Practically, yes. Legally, the judge couldn't require it, but a judge would, those judges are pretty, they don't like to be heavy-handed. So they would at least ask the parties to do what you could. But it sounds to me like you've already done it. So your attorneys would that's the first thing your attorneys would say, we've already done it, in which case the judge would, the judge is probably going to, and I'm just speculating here, but more than likely the judge would probably give them maybe 15, 21 days to move themselves, after which point in time, then the sheriff would step in. In fact, actually, we require the sheriff to probably go out there and give them the notice, give them 21 days.
All right, I think you guys are working on that. I want to go back to one other thing. So, Mike, you do not have a building permit to sprinkle the one building. You don't have a plan, you don't have specs, nothing,
No.
which was part of the 120-day, I believe.
There's a permit
Continuation?
application in for the utilities portion to get water supply to that. We've had our existing sprinkler contractor that we've used forever has been non-responsive. They lost three of their superintendents. We've had two other sprinkler contractors in. We've got a quote back from one just this evening, and he thinks he can get the work done. He's got to develop a plan.
Which we've been asking for 120 days.
I understand, but a plan means that he has to come out and literally draw the building because we don't have any architect or structural drawings for the building, and do structural analysis to make sure that the pipes hanging from the ceiling will not tear the roof down. It's not a simple submit a sketch on a piece of paper and submit it. You have to have flow.
I understand that, but that's why we keep continuing this, waiting for this. Now you're asking for, how much longer for that?
I'm saying that by April 10th, when the utilities guys start, which is what they have on their schedule to start, we want to have that sprinkler work all in. So a plan submitted,
Oh, back
permit
up.
pulled.
Where are the plans? If you're gonna have it started April 10th, you gotta have plans way before that.
Yeah, he got me the quote back this afternoon, and I sent him a contract to sign to start working on it so he could get us plans, which he needs to submit to get a permit pulled. The permit's already pulled or applied for the underground utilities portion. And this contractor works with the underground utilities. That's how we got in touch with them. The utilities guy gave us a reference because he knew that we were struggling with the other sprinkler contractor that is the one that brought him into the loop in the first place. So we are trying. But trades are, everything's tough to get service right now from
Look,
anything.
I get all that, but like I said, over a year so far, what I can count, and 120 day was our drop dead deadline, and here we are. You still want another 120, 180 days. I can't emphasize anymore how frustrated I am with this whole process.
Well, extremely frustrated, but the fact is that outside of the sprinkling part, they have a permit. You've issued a permit to do everything but the sprinkling part, which gives them 180 days. Am I correct or not correct?
Correct.
Okay, so my question is, how difficult, and you haven't been involved, have you been involved in this process you're at a detailed level for how long?
I got involved when Mike and Kurt first walked the plant in April of 2021 and found deficiencies that we needed to correct. And I've been with the company for 17 years, but I had just started in this role at this plant January 1st of that year.
Okay. My comment is, there's no question that you didn't have a building permit to do the building. I mean, I don't think no one's in dispute.
Nope.
So what the question is now how to move forward. And the options are to shut the door or come to some agreement that we can live with. So how fast can you get detailed plans together for Mike? I need to know that.
For the sprinkler
Yes.
portion?
Where you have a commitment that it will be done on a day certain.
So in talking with the contractor that was out and gave us the quote today, he thinks he can have plans ready and a permit in a few weeks, and then have his work, if the permit gets approved, has his work done by April 10th, which is when the underground utilities contractor has us on their schedule. They've already applied for a permit and provided plans for the underground work. On April 10th, when he hooks up our underground utilities, or that week, the sprinkler guy just has to come in and connect it, and then the alarm company has to do their thing. And by April 20th, hopefully, we're completely done.
April 10th, the frost won't even be out of the ground. Again, now.
Look, I'm not a construction expert either in terms of underground utilities.
All restrictions will still be on.
Industrial utilities has told me. So I don't.
All right, getting back to
I
your
got to
point
defer
of
to the experts.
180 days, but you also have 7 buildings out of compliance,
You do.
which means that building permit's not going to be satisfied to allow them to operate in those buildings till the work that you propose to get done. And I still think that is still an issue with the township. We're allowing someone to operate in a building that's not been ordinance specified.
Well, I mean, let's be clear. It doesn't create liability on part of the township.
Well, it makes us look like it's awful simple to just come into the township, do whatever you want, and
Well, I'm not denying that, but I'm just saying from a liability standpoint, it does not create liability on part of the township.
well, I get it. And that's not our call, I guess, if they want to continue this without, they must feel pretty confident that these buildings are safe. But I rely on what Mike says. Well, granted, if Mike's issued them a permit and we have to legally give them 180 days, I'm still not comfortable letting them work in buildings that aren't fixed.
And the fix on the 6 is anchors. Yes?
So there was a complete design done by a structural engineer describing what needs to be done to be in compliance with the building code. So
And that's just a matter of anchoring the buildings into the ground.
there was a few odds and ends.
But that's the main issue, that they're not properly
Anchored. I believe there was some bracing required, miscellaneous through a couple of them. Overhang cut back. Again, miscellaneous repairs.
All right, any other questions of the applicant?
Can I ask a quick question? You said the one building's been there for 40 years. Any idea what its use was when it was first constructed?
Sure, there was a lumber stacker piece of equipment in it,
Okay.
and that was taken out. Now there's a panel saw that cuts plywood.
When was that put in?
2014.
Okay, thanks.
All right, Scott, anything else?
Is the CUP and the permit in alignment now?
It is.
Good, okay, that was it.
All right, Steve?
but not the CUP as it relates to, and the building permit for everything but the sprinkling portion, because that's where I'm confused. This is all one blend of a situation started by no permits. But what Scott asked, the CUP and the plans deal with everything but the sprinkler.
The CUP specifies, the sprinkler requirements. This is like the third time that we've had to go through the process. So the language that's in the current CUP describes exactly the number of buildings, and the expansion of the panel cutting building, which requires the fire suppression, and all those details.
I gather that, but the building permit that you issued is for what?
Construction of the structures. You need
Mike, actually, isn't for repair of and modification of the structures to meet the building code?
you have to have a building permit to construct the buildings. The town issued a building permit to construct the buildings. For us to approve the construction of the buildings, the property owner must comply with the engineer's design repairs.
Okay.
So once those repairs are done, the town can approve the building permit for the construction of these buildings.
Approve this occupancy of the building, you mean?
Correct.
Okay.
So can we define occupancy?
People being in the building.
There's nobody in the buildings. They're literally packed back to back with lumber. Nobody can get in the buildings, human beings. A forklift can get to the
Take the lumber out and put it back in.
forklift can get to the edge of the building and pull it out. That's it.
Okay, well, that's interesting.
With a roll cage. They're wide open ends. They're literally carports, like you would buy at Menards and install without a permit. Like, that's literally what they are.
It's different.
And there are no humans in any of those unpermitted structures. There are humans in the sprinkled building, but it's attached to one of the unpermitted structures that is to protect that inbound area where the forklift drives up so that we don't get snow and ice accumulation right where a forklift meets a human being.
Right. Got it? No.
Okay, I'm doing it this time.
We can take a walk. It's right there.
No, I realize that. No, I gather I've heard what you said, and it goes back where thou shalt understand you did not have a building permit. There's no argument about that.
Correct.
It's how to resolve the situation at this moment.
Correct.
So our choice is to shut you down or come to something that we can all live with, is what.
And I would politely and respectfully ask, one, thank you for your patience. I know that this has been a long process. I'm as frustrated with you guys with this process, trust me.
Well, it sounds like you got thrown under the bus a little bit on this one, too.
Whatever. That's here nor there, right? To your point, how do we move forward? And we've got a contractor under contract to make the repairs. It says he can have them done by, May 20th that Marcus says? I think. May 20th, which is 60 days past the 120 days that was originally given. And then we've got a permit applied for an underground utilities contractor for the sprinkler work that has on his schedule to do the work the week of April 10th. And a contractor that I think will be able to get a permit, a official plan and permit application in a matter of a week or two, and be able to have his portion of that work done in time to just hook up to these utilities, call it by the end of April at the latest. And I know that that's extending further. I don't have any other way to resolve this faster. I mean, you mentioned thawing the ground, and we can certainly look into that, which I'm not an expert on ground thawing, what that costs, and whether the anchors that are being used can even be done with a thawed ground that's going to refreeze, because they seem to have a concern with how the anchors will grab into the soil and the tensile strength of the anchors when you put them into the, I see engineer on your nameplate, so maybe you can speak better to some of that stuff. But I have to defer to what the experts say. And these are general contractors, commercial general contractors that have been in business in Minnesota for a long, long time.
I know I looked them up.
Yeah, they're reputable. They do a lot of work all over the country. They've been a great partner of ours for a long time. They built the existing building that we had approved in 2014, I believe. I have to defer to their expertise.
All right,
And I pushed
Mr.
them.
Chair, can I make a suggestion? Why don't you adjourn this till the second meeting in March to see if the plans for the sprinkling system have been submitted?
I don't know, there's there a 90-day rule or 60-day rule on that?
No, this is not, this is building code, it's not.
Okay.
See, the zoning issues have already been dealt with, now we're down to building code.
I don't know, how's the board feel about that?
Well, I feel better about it. I like to see concrete plans.
It's fair.
You know, I don't like to kick it down the road and say, well, another 30 days, another 60 days, another 120 days. Then it's just continues on and on and on. And as the chair said, you know, as we've been looking at this for a long time.
Yeah.
All right, Brian, I noticed there's somebody else, is there somebody else you want to speak to this or not? All right,
Caleb.
well, if there's no one else who wants to speak to this,
So would we continue this hearing?
Yeah, I mean, I use the term adjourn, you're correct. It could be, you simply continue this hearing until your second meeting in March, or the first meeting in April, whatever you want to do, but just continue it.
But we shouldn't close the public portion, or close the public portion but not?
No,
No,
if
we're
you're,
gonna
if you're
continue
going
into
to continue this, I would keep the public portion open.
Okay.
Because for the simple reason that one of the issues that's going to come up is the plans, if they've been submitted or not, or haven't been submitted, and you're going to want to find out why.
all right, well, if no one else wants to speak, then I need a motion to close the public portion for now.
Well, no,
No? Or you want to leave
hang
it
on,
open?
Just continue the
Well, we can
hearing.
continue the public hearing, but do you want to? All right, never mind.
you know, the motion would be to continue this hearing.
Okay.
Until, again, whatever meeting you want to continue to, and also at the same time to keep public testimony open until that point.
All right. Sound like a motion for you, Steve?
Yes. This motion,
Second that.
okay.
Is that the 20th of March? Is that
All right,
the
motion made. All in favor, say aye.
Sure.
Aye. We did not set the exact date, Mr. Chair. Do you want it on the first meeting in April, as it's closer to when the anchoring and everything is supposed to be done?
That might be smarter.
I think we'd be better off to have it the table till almost to the, you could almost do it to the 17th April.
April 3rd.
3rd and 17th is our,
That's a whole month.
we'll go to the 3rd.
Yeah. There's no reason to go any longer than that.
The 3rd.
All right, got to work for you guys.
3rd of April.
Very fair. Thank you.
All right, so now we.
All right, moving on. Item 8, new business, we have none. Item 9 is the added agenda item for the special board meeting for,
March 7th, 2023. You have the details there, correct? Okay.
and what's this for, Scott?
Okay. Scott, you want to read that, what it's,
The White Bear Area Chamber of Commerce is having their 2023 legislative reception at TRIA from 4:30 to 7, where elected officials from the state, county, municipalities, and the White Bear Area Chamber Board of Directors will get together and mingle. So I know we went to it a few years ago before the whole world shut down, and it was an opportunity to.
Well, you and I were there, yeah.
Correct. It's just an opportunity to meet some of the legislators and have them meet us. And
And also put a little pressure on them for our
Exactly.
lobbying for some,
Opportunity.
it was an opportunity to network.
all right, so I have a motion for that?
yeah, I'd move to call a special meeting for March 7th for the day, I guess. Might as well just leave it
4:30,
open.
okay, yep, for the day.
To attend a local legislative meeting.
Second.
All in favor, say aye.
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 All opposed? All right, that motion carries. Item 10 is open time. Mike, you got anything? Not today. Okay,
Anybody else?
hearing none. Need a motion to receive agenda materials and supplements.
So moved.
Second.
All in favor, say aye.
Aye.
And I need a motion to adjourn.
So moved.
Second.
All in favor, say aye.
Aye.
We're adjourned at 8:09.
Thank you, gentlemen.